It's a quickie life. A previous quickie covered how slippery slope is not a fallacy, and the Supreme Court found just that in Boyd v. United States. In 1884, 35 cases of plate glass were seized at the Port of New York from E.A. Boyd & Sons for not paying import duties. The government needed to prove its case, so they tried to compel Boyd to produce the invoice. Boyd complied, but objected, and his appeal went all the way up to the Supreme Court, who ruled, a compulsory production of a man's private papers to establish a criminal charge against him or to forfeit his property is within the scope of the Fourth Amendment to the Constitution. Not only that, but it violated the Fifth as well, being testimonial in nature. Any forcible and compulsory extortion of a man's own testimony or of his private papers to be used as evidence to convict him of crime or to forfeit his goods is within the condemnation of that judgment. In this regard, the Fourth and Fifth Amendments run almost into each other. But the really important principle is how this needs to be stopped for any violation of the Constitution, no matter how insignificant. They ruled, it may be that it is the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. In other words, the slippery slope is real and you need to stop things before it gets going. Ironically, since then the Supreme Court has tried to slowly walk that back, allowing more and more intrusions into the Fourth and Fifth Amendments. When you see something done against someone you don't like Alex Jones or Donald Trump, or it seems so mild you wonder why anyone would bother fighting it, understand that's how they get you, and they'll end up with the power to use it against you in the future. Eternal vigilance. That is always the price.